Hello, I'm Mary Azcuenaga, and I'm very pleased to be here today with Roxane Busey, a distinguished antitrust practitioner and a prominent leader in the antitrust bar. Roxane is currently a partner in the Chicago office of Baker & McKenzie. She served as chair of the ABA Antitrust Section from 2001 to 2002, and as chair of the section's task force on the Antitrust Modernization Commission from 2003 to 2007. Roxane, welcome, and thank you for being here today.
Thank you, Mary. It's a pleasure.
Well, let's start at the beginning. I'd like to go back a little bit to your personal background. Can you tell us a little bit about where you were born, where you grew up, and so forth?
I am from the Chicago area. I went to public school in Chicago and then on to a private high school. From there, I went to Miami of Ohio, and I graduated with a degree in English, essentially. I had always wanted to be an English teacher, but in college I had not taken any of the education courses that were required. So my next step was to get a master's in education from Northwestern, and then I taught for 2 years high school English, 2 years at New Trier, and then decided that maybe I should try law school. I had taken a course at Miami in constitutional law, which I found to be fascinating. And I went to my counselor at that time and said to him that I was interested in law school. And he said to me, well, you should go right away to law school, Roxane, or you will never get there. But I had other plans, and so I did my teaching, and then I went on to Northwestern, and that's where I received my degree. And from there, I went and began practice at Hopkins & Sutter in Chicago, and I practiced there for about 20 years. And then I went on to Gardner, Carton & Douglas, and I practiced there for about 10 years. And now, as you know, we are both partners at Baker & McKenzie, with me being in the Chicago office and you being in the D.C. office. That's my background.
Well, it's a great background. Let me ask you, from your years as an English teacher, was there anything particular about teaching that you brought to the practice of law?
Well, I had thought initially that I would be a litigator, and I think that came from the idea of being in a classroom day after day, being in front of people, trying to convince them or teach them or whatever, discipline them or whatever. And so I had thought that perhaps that would be an area that I would pursue. And in fact, my first year at Hopkins, they had a mandatory rotation, and my first year at Hopkins was in the litigation group. So I did get some early experience in litigating, and I do think there are some skills, some verbal aspects of practicing law that are not dissimilar from teaching. And I've also felt, I haven't done a lot of jury trials, but I've also felt that that notion of simplifying things to a jury, as you would do sometimes to a class, would be a skill that would be used in different situations.
Mm-hmm. Mm-hmm. Well, when did you first become interested in antitrust?
Well, I had taken antitrust when I was at Northwestern, and I did enjoy the course. But at that point, I was thinking more, I guess I should say I was thinking more generically about would I do litigation, would I do tax, whatever. And I did my first year in litigation as a rotation, and I actually did my second year at Hopkins in the tax section. They were a very well-known tax practice, and I had taken many tax courses at Northwestern. Coming back to litigation, my third year, was when I was approached by Mark Crane, who at that time was the head of litigation and the head of the antitrust group. And he asked me would I consider spending some of my time in the antitrust area. I think he recognized, as all antitrust lawyers recognize, it's a complex field, and it's a field that you really have to keep up with current developments. There are always a lot of things changing. So I promised him that I would do that, and over time it just sort of took over more and more of my time, and the next thing I knew, I was doing 80 to 90% of antitrust work. I think one of the things I should say is that I was fortunate, not only in working with him, but also the practice there was not a large practice, and so it enabled me to do different kinds of antitrust. You know, if it was a Robinson-Patman question, it came to us. If it was a merger question, it came to us. If it was a criminal question, it came to us. So it gave me a very broad base, And also, I think, was one of the reasons I continued to be in antitrust as opposed to going off and doing other types of work.
Well, that's something I was interested in. You more or less fell into antitrust.
More or less, yes.
And after you had been in it a while, you stayed. Did you come to like it, or did you just stay in it because you had always been doing it, or had been doing it for a long time?
No, I stayed in it because I did like it, and I still like it. And I think that's a very positive thing to say after so many years. I've always found it to be very challenging. I've always appreciated the fact that it was an in-depth specialty. So as a woman, it was very helpful to be able to be knowledgeable in a particular area. But also it enabled me to look at different industries and to learn about different industries. And I found that to be, and continue to be, a very exciting part of the practice. I guess I would say the most recent change, which I'm sure I'll be talking about, is at Baker & McKenzie, what's been added to my practice that I didn't have personally so much before was, of course, the international dimension. And that, of course, is just amazing and has a lot of challenges and complexities associated with it. But that's continued to maintain my interest and continue to challenge me.
Great. Well, it is a great career. And so you've done all the areas of antitrust, which is great. And you've also done, I believe, both counseling and litigation.
That's correct, I have.
What are some of the more interesting matters that you've worked on?
Well, you know, I was thinking about that, and some of the counseling matters I'm probably not at liberty to say too much about. I guess I would say that more recently, doing some of these global compliance programs in antitrust has been challenging and interesting, and has required me to really be able to understand our laws better and to be able to make a comparison to other laws, to see where the differences are, to see where there may be some areas of convergence, and yet there are many areas where there are differences. But I have had some other experiences that I can talk about more specifically. One that I thought might be interesting, really from a historical point of view, was in the early 80s, my firm was hired by the Illinois Department of Insurance and then by ISO because there was pending bills to repeal McCarran-Ferguson. And my assignment was to say, well, what would be the implications of that? If McCarran-Ferguson were repealed, then what would happen from an antitrust point of view to all the normal practices of the insurance industry? And what I think is so amazing about that is, of course, there's still bills pending to repeal McCarran-Ferguson. And I'm ready. I've been ready since 1980 to answer that question, but, you know, it hasn't happened yet. So, but there have been some litigation matters that
May I pause and ask you, what is the answer to that question?
Well, of course, you know, we have the information sharing, and there would be certain lines that would have to be drawn there, and there are questions about the pooling that would have to be analyzed, and there are questions in reinsurance, and so there would have to be careful review. You know, we have state action also, so one of the questions that would come up is if McCarran-Ferguson isn't there with a state regulation, would that be sufficient to trigger a state action defense? And of course it would vary from state to state in terms of what their rate regulation was, whether there were the requirements of state action. So a complicated answer. And I hope that if they do, in fact, repeal McCarran-Ferguson, that someone is giving thought to what all the various ramifications would be.
Right. It's one thing to say that there's exemptions from the antitrust laws are not a good thing, but another when there are so many complexities in a particular industry that has been exempt for a long period of time.
Right. It becomes really the unintended consequences. Have they really thought through what the ramifications would be?
Right.
I think.
Right.
Right.
Well, we'll call you when that bill passes.
Well, we'll see. Another matter that I thought might be of interest that I think you might know something about is in the mid-90s I was involved in merger litigation. And I had been involved with mergers before, but it was actually the first time that I was involved in the litigation aspect. And I think that, of course, enabled me to see the full picture, not only just when you file or when you go into the agencies, but what kinds of arguments and how do you need to be prepared when you're actually defending a merger. And I'm talking about the acquisition by BAT of American Tobacco. I was one of many attorneys working for American Tobacco, so we were the target. And the transaction was challenged by the Federal Trade Commission. And I could be wrong, Mary, but I think you were on the Federal Trade Commission at that time.
That might be.
And I think Christine Barney might have been there too.
Could
In
be.
any event, what was interesting to me, and I think what raises the question now, is in that industry at that time, the merger would have resulted in, I think what everybody agreed to, was about an 18% competitor. And of course there were two larger competitors, Philip Morris, which was huge, and R.J. Reynolds. And so this would have created what I would call a strong third. And to my amazement then, and still to my amazement now, it was challenged by the Federal Trade Commission. It went to the Southern District of New York before Judge Milton Pollack, a very respected and elderly judge. And it actually went through all of the evidence was presented, and then he was about to rule. And it was at that point that the case was settled with the Federal Trade Commission with the divestiture of a few of the brands. And then the merger actually went forward. But to me, it was an amazing experience. My involvement was working principally with the economists. And the theory of the case, from the FTC's point of view, was that even though it was a third and didn't have a huge market share, that it was a maverick. So I became more knowledgeable about the concept of what is a maverick. So that was one case that sort of helped me because I started to do more mergers, and now I could understand not only from the filing, but actually all the way through what would be some of the arguments and what would be the analysis that would be most appropriate. Another case that I worked on that I think was of great importance to the industry was the National Resident Match case, which was a class action that was brought by three medical residents who claimed that my client, which was the match, and most of the major teaching hospitals in the United States had conspired illegally to fix the wages of medical residents. And what was interesting about the case is, from my perspective, it was not a per se case. It was a rule of reason case. And it didn't mean that the match had nothing to do with the wages that were set. They simply, well, maybe I should explain. The match was medical residents, all medical residents in the United States, would indicate their preference as to which residency program at what hospital they wanted to participate in. And at the same time, the hospitals would all rank the students to come into their residency program. And then the match, which was my client, a nonprofit organization, used an algorithm to get the best match possible for the student. And that's what we did, but the allegation was one of our rules for participation in the match was that you had to accept the match, the assignment that you were given. If you participated in the match as a medical student, then if you were matched with X hospital, you had to accept that. And the plaintiff's theory was that that took away the bargaining power of the individual residents because they had to accept the match. And whatever that hospital paid as their wage, they had to accept. And to me, this was just, again, one of these crazy cases because I always would analogize it to law clerks or first-year students coming out of law school thinking, well, what bargaining power would they have, particularly in this economy, to affect what they might be paid? Because typically, whatever a firm says they're paying, nobody really has much authority or power to bargain for something better or worse. In any event, that was the case. What was fascinating to me was, first of all, I had the opportunity really to work with Al Roth, who was a game theorist at Harvard. And he was the one who had put together the algorithm for the match. And he was sure he could defend it, that it was the perfect system. And he was very impressive and would have been a great expert. So that was one thing that I was very pleased about. But the other thing that I was very pleased about, or which I thought was very interesting to follow, was even though we felt that we would ultimately win the case, that this was not a case that the plaintiffs would succeed on, that there was a lot of disruption in the industry. And there was a lot of expense to the hospitals, to my client in defending this, as you know, in litigation. And the medical residents were concerned. I mean, this match had been in place for 50 years. They relied on this match. And they didn't always know whether it would be there the next year for them. And there was a single day called Match Day when they would all find out where they were assigned, and it was a problem. So we actually hired additional counsel, and we managed through this council to have federal legislation passed to exempt matches of this kind, medical matches that were based on this kind of theory and algorithm. And so the case never proceeded to trial. It wasn't even, the class was never even certified, but it was kind of just an amazing experience and an important one for the medical profession.
It certainly was. Well, it sounds like a fascinating case.
Yes, it was good. It was fun. And the last thing that I guess I would mention is that I recently had the opportunity to serve as a special master in a federal antitrust case. It was a staff privileges case, and it involved the exclusion of a physician from a hospital. And there had been quite a bit of discovery, and both sides had economists. And the judge felt that there was so much paper that had been submitted, and the concepts were very complex, that she would appreciate having someone who could advise her. And so I was retained to assist her in ruling on a motion for summary judgment and on a Daubert motion to exclude the plaintiff's economist. And so this went on for quite a while. I mean, the work probably involved maybe a year long, going through the documents, talking with her, having her, make her decision, hearing oral argument, this type of thing on both motions. And for me, what was interesting about it was it gave me a perspective on judges and people, actually like yourself in the Federal Trade Commission, who actually have to decide something. I'd always been in the situation where I had counseled or where I had advocated, but I'd never before been in a situation where I actually had to rule. And it wasn't my ruling, but I was advising her. And it gave me a new appreciation for judges and the people that need to make those kinds of decisions. So Mary, I've been very fortunate. I have some very interesting cases throughout my career.
You have indeed. You've done actually quite a bit of litigation, and I would say that the assistance you gave to a judge in terms of decision making is an aspect of litigation as well. Do you think that's informed you in the rest of your practice or helped you?
Absolutely. I do, and I think that when I started at Hopkins, the antitrust practice was in the litigation group, and the concept behind that was that you had to fully understand the risks associated with litigation in order to be able to advise a client in terms of what was the best and the right practice, but also what were the risks if you didn't follow that advice. And so absolutely, I think it's very helpful that although I've never been really a first chair litigator, I fully understand the litigation process and the litigation risks. And I do think that helps clients to understand more fully my advice, my recommendations, and then make their own decision.
Absolutely. Well, also, antitrust litigation has been sometimes criticized for being long, burdensome, and expensive,
Yes.
somewhat unpredictable.
Yes.
Now that you've done litigation, antitrust litigation,
Yes.
do you have any thoughts about that? Is it justified? Is it unjustified?
I basically agree with that. I think there should be a shortening of the process in some way. I've seen that in a number of situations. In the match case that I mentioned, we knew that we had a case that we could win. We also knew that the process made it very difficult for us to get to that result. And so it looked like the choices were to settle, and that would have been disastrous for that industry because that's the way that medical residents have received additional training. It would have been very difficult. And the only other option was federal legislation. And candidly, we didn't think we had much of a chance to get a federal exemption for the match. And so we were fortunate that we did. I've also been involved in, not in a major way, but I've been involved in a number of class actions, and the process there is very long and very difficult. And I would like to see some shortening of that. When I served on the task force to the Modernization Commission, We looked at a couple of litigation points. We looked at the right to contribution, which is a little different than what you're talking about. But we also looked at Illinois BRIC, and we made a strong recommendation that if there were going to be all these individual suits brought by states, we might as well repeal Illinois BRIC and come up with some other solution for at least putting all of the litigation in one forum and dealing with one law rather than various laws and situations. So, yeah, I would do a lot of revision to litigation. How likely that is to occur, I don't know. I don't know.
Well, maybe we should put you on that task. You seem to make a lot of progress, everything you endeavor.
Well, I wish I did, Mary. I wish I did.
You've done several antitrust healthcare matters, have you not?
Oh, yes. When I was at Gardner, Gardner was very well known for having a national healthcare practice. And I was very fortunate to have many different kinds of healthcare assignments. Some of them would involve staff privileges, exclusive contracts, just a whole array of things. But I think I'm mostly known because during that period, probably from about 1995, maybe a little earlier, until into the 2000s, there were a lot of consolidation in the hospital industry, and there were a number of hospital mergers. And I counseled many hospitals on their mergers. I can't even tell you how many. None of them went to litigation. I was ready, but none of them went to litigation. One of them, which actually never was finalized, but involved 7 hospitals in a larger community. And we did the analysis, and we thought that it was okay, but then there were other reasons why it didn't go forward. So yes, I've had a lot of experience in the healthcare industry, which I have enjoyed. I think healthcare is a very important part of our economy, and it's certainly a challenging area to practice in.
Do you think that antitrust is, that the antitrust enforcement and the cases have taken generally the right direction with respect to healthcare?
You know, I think that's a very hard question, Mary. I know that the agencies have struggled with hospital mergers, having lost many of them, and then more recently having won the Northwestern Highland Park retrospective merger. And I guess I think things are a little bit in reverse. I guess I think that there might have been some hospital merger cases in the small towns that perhaps should have been stopped. But, you know, I'm from Chicago, and to see the challenge of Northwestern and Lake Forest in this big city be the success of the agency was a little bit of a surprise to me. You know, they moved, because it was a retroactive challenge, they were able to move directly to adverse effects and pricing. And they were able to show, although, you know, candidly, it was all sealed, so we couldn't really see it. They were able to show that as a result of the price increases that it was an unlawful merger. But it just struck me as odd that even though in these small communities where it would go from 3 hospitals to 2 hospitals or from 2 hospitals to 1 hospital, that the agencies would not be successful, that in this big market with many hospitals, these 2 weren't able to fully merge. So I don't know the answer to that, Mary. I know the agencies struggle with this as well, but it doesn't strike me as that that's quite the way it should be.
And do you think that's partly because of the judiciary and their approach, or?
Well, there are issues with the judiciary. There could be some of that. I think that's faced with whatever goes before the court. You know, the courts vary very much, and there may be some local interests that are coming into play when you're dealing with hospitals. That's very possible. It's very possible, Mary.
Great. Well, let's turn for a moment to the ABA.
Yes, sure.
When did you first become active in the antitrust section?
Well, I became active probably in the early 80s, and that was because Mark Crane had been very active in the section, and the firm generally encouraged participation in the antitrust section. So I started going to meetings and volunteering for projects along the way, and found it to be a great organization. I mean, it was always very exciting to come to the meetings, and the programs are very good, and the publications are very good. So I felt very comfortable in the organization, even though I didn't know very many people. I felt very comfortable in the organization. And then in 1986, I was appointed as vice chair of the healthcare committee. And so that put me for the first time really in a leadership position. And my chair at that time was Phil Proger. And you know, he was very helpful in terms of my understanding of how the section really worked. and what he expected a leader, even a vice chair, to do. So I learned quite a bit from him in terms of how to run a committee. And of course, from the vice chair, I moved to being the chair of the healthcare committee. And that was a total of 6 years. So a lot of time in understanding how committees functioned and what they were to produce and the opportunities really that they were to provide for other people. You know, once you have a leadership position, it isn't really so much about you, it's as much about the opportunities that you can afford to your other committee members so that they can learn and kind of move up the ranks. So that was the beginning. And from there, I moved I was healthcare committee chair for 3 years, and then I moved on to the council and served there for 3 years. And then I had a number of officer positions. I think they were treasurer or finance officer and secretary and vice chair. But the point was I began to see a bigger perspective than just what the committee did. I began to see what the section did and all of the issues that would come before the section, not only in terms of its own management, programs and publications, but also a lot of policy issues now started to come before me. And so naturally it expanded my practice, because now I knew more because I had listened to these policy issues and sometimes was asked to actually comment on some of the policy issues. So that was good. And of course it culminated with my being chair in 2001, as you have said.
Well, what were some of the issues that were under consideration when you were chair?
Well, I had to go back and look, Mary. I couldn't remember what was going on then.
There are lots of issues.
There were lots of issues, and there were a lot of memories that came back. The first thing that I would say is that I felt that I was prepared to be chair because it had all this history with the section, and I had all these people who were very supportive and taught me along the way. But of course, the first thing that happened, well, I guess first we had a leadership meeting in August, and that was good and memorable in part. In fact, someone came up to me even at this meeting and said, "I remember your meeting in Colorado Springs because." We had as our I don't say entertainer, but we had as part of our meeting not only the substantive meetings, but we'd had Shannon Miller come, who was a, an all-round gold medalist in gymnastics, mm-hmm. and she actually performed for us. And that made a big impression on people that, because we were in Colorado Springs, and that's where the Olympics, that's where their headquarters was, and so that was there. So we started off kind of well, we were going well, and then of course 9/11 hit. And that was just a month into my term, and there was nothing that was going to prepare me for that. And we had to deal with some of the practical issues. One of the things that we did was we had a merger program that was scheduled for the fall, and we had to move that to the spring because we didn't know if people would be traveling. We didn't know if they'd be going to programs. We also did a good long look at what would happen if we didn't have the spring meeting. Financially, what would that do to the section, that kind of thing. Even though it was set for April, in September, we didn't know. And so there were things that we had to do that were somewhat unexpected. However, it was, in terms of just coming in, every year is a little different. This was the beginning of the Bush administration. So there was the need to reach out. At that time it was Charles James, who was the head of the Department of Justice, to reach out to him. And Tim Uris was the head of the Federal Trade Commission, to reach out to him and to make sure that they were willing to participate in our programs, that they would come to our meetings to report, this type of thing. So that kind of sets the time frame. It was also the beginning of ICN, the International Competition Network, and that was very exciting. It was the first time that, not so much the section, but that the governments were trying to hold a meeting to begin to look into some of these difficult global issues. And I remember, I don't know if it was the first paper that the section did, but I do remember that in my year there was a paper on, I think it was merger control, that was submitted to the ICN. Probably, it might have been the first paper submitted to the ICN from the section, but one of many that the section would follow up in terms of trying to assist them in their work, which is not insubstantial. So that was going on. Then we had the intellectual property hearings that were being held by the Federal Trade Commission, and I remember as chair I would be the spokesperson for the section. I remember speaking on behalf of that. That was going on. We also had a question come up with respect to disgorgement. This was at the time of, I think it was around the time of the Milan case, and there were questions about what's the appropriate disgorgement that the FTC should use. And the section submitted a paper recommendation to the Federal Trade Commission, and that took some debate and discussion. And then shortly after that, the FTC came out with its position on disgorgement. But I also remember, because this came up unexpectedly, I'm beginning to think my year was a year of unexpectedly. We had another leadership meeting in January in Puerto Rico, and the question that came up unexpectedly was the clearance agreement that had been reached between the Department of Justice and the Federal Trade Commission with respect to the various industries that they would review. I think it was limited to mergers, but I'm not sure about that. And it was very controversial. And for reasons that aren't entirely clear to me, it was felt that the section should take a position. So the first thing on our business agenda was to deal with this question in terms of, did we support a clearance agreement? And if so, did we support the clearance agreement that had been reached? And I remember it so distinctly because I hadn't had any time to think about it, and I remember all these people. It's a fairly open meeting. If you're invited to the meeting, you're certainly welcome into the council. And all these former chairs came in. I think they wanted to make sure that we did this right. And we ended up saying, that we ended up deciding that we agreed that clearance would be good. It would be that an allocation of industries for the clearance process would be good. It would be an efficient use of government, given that we have two agencies. But that by no means were we going to say which agency had which industry. As you can imagine, that was a serious, serious problem. And you probably know how that turned out. That ended up with no clearance agreement, but not because we hadn't supported it for whatever that was worth. So those are the things that I really remember from my year in terms of some of the issues that we dealt with.
Was the clearance agreement the most controversial matter you dealt with?
It might have been. It certainly was one of the more political. Okay, and the section is not afraid of political issues, but they try to hold fast to some basic principles of either antitrust or good government or transparency. I mean, whatever it is. And in this particular situation, I think they were trying to deal with the fact that we have two agencies. We respect that. But there might be times when it is appropriate for some agreement to be reached between the agencies. And on clearance, where there's delay, sometimes, not always by any means, but sometimes, if it would help clearance to be because there's already been a predetermined allocation by industry, then the section was going to support that as good government, essentially. Right? Yeah. So those were, some of the issues that we faced that I recalled when I went back and looked. I think I did look. You can go on the website and you can see all these things. And in the year, my year split between 2001 and 2002, it looked like we had about 20 different issues that we commented on, and some of them I just blocked out. But yeah, those are some of them.
That was a lot of issues and a lot of challenges. What do you think were your greatest contributions to the section?
Well, I hope that I made some contributions along the way. I guess I should say that in the healthcare committee, which I think prepared me as much as anything to take on a management type of role, I think that I helped the committee become very productive and created some opportunities for people. So I think that was something that went on then for many years. The healthcare committee was just a very well-run committee, and it started with someone like Phil Proger, who had a vision as to how it should run, and then I would implement it, basically, and so that was good. As section chair, the two things that I was focused on were, it was the 50th year of the section, so there were some things that we did in celebration of the 50th year. I remember Steve Calkins wrote a paper on the history of the section over 50 years. We had a big chart that was in the magazine, and then it was displayed during the spring meeting, and it showed every chair for each of the 50 years and something that had happened during their year. So that's kind of nice from a historical perspective to have that. And then it was the year that ALD 5 came out, and of course, antitrust law developments is, very good. And none of these things were just me. That was Debbie Pearlstein and a whole bunch of people that contributed to that. So that was another positive thing. But in terms of my own contributions, I would say most of them were behind the scenes. What I remember was that was the year that I think we put in place, I don't think we picked, but we put in place an international officer. There had been some debate within the section as to whether we needed an international officer, and I had advocated for that, knowing that that's a big responsibility. And if the international responsibility was also going to be the responsibility of the chair, it was going to be a huge job. So we got an international officer in place. I put in place a couple of we had a committee officer, but we had all these committees, and I put in place another committee on committees that helped run the committees so that they could, what we would do is we would take some of the very best committee chairs and then we'd put them in this committee on committees, and then they would sort of share their best practices to get all of the committees functioning as best they could. And you won't know about that unless you ask me about something like that. And the other thing that I did that was very helpful is whenever I took a new position in the leadership, it was always kind of like, well, what are we supposed to do kind of thing. I remember when I was treasurer, I didn't quite know, well, what did that mean? So I started with the officers, and they've now extended this down. We put in someplace best practices. So I put together, I think it was about 10 pages of best practices for the chair, and said to the person, Bob Joseph, following me, here, this is a starting point for you. And they've continued to do that. So now there are best practices for all the officer positions, all the council members, the committee chairs. Everybody has a sense of what's expected of them and some of the time frame. So again, these are things that are kind of behind the scenes, but I think, help the section produce and manage as best they can. The other thing that I recall that we did we worked on with Kathy Fenton, who was publications officer at that time. We put in a long-range plan just on publications. So we know in ALD 5 and 6 and 7, everybody knew when that was going to happen. But in terms of some of these treatises that just would be out there and they wouldn't necessarily be revised, we picked some of the major ones and said, well, in this year we're going to come out with the 2nd edition or the 3rd edition. So we did some long-range planning in that regard. So you know much about the section. I mean, it's a very productive section. So the more you can do to organize it and to keep it running, I think that's important.
That's a great deal, Roxane. I'd just like to go back to your background. In addition to all the positions that you've had in the antitrust section, which of course is a great section, you were also the chair of the antitrust section of the Chicago Bar Association. You were the chair of the Illinois State Bar Association's Antitrust Council, chair of the Healthcare Committee of the American Health Lawyers Association, among other things that you've done. I've been an admirer of yours for many years.
Oh, well, you're very nice, Mary.
Because I think that you are so capable and you get things done. I think this list of things you've just described indicates how you get things done. And while you're doing that, you also happen to be one of the nicest people in the antitrust bar.
Well, thank you.
So here's my question.
Well, wait, let me say something. It's nice of you to say all that, but it's a way of having other people do all the work, right? It isn't just me, because I'll say, okay, we need to do this project. Who will do it, right? So.
Well, here's my question. Mm-hmm. What's your secret?
Well, I don't know that there's any secret, and I think that anybody that would look at sort of starting from the beginning and going to the end of whatever the project was, I think it's mainly an organizational type thing. I do think that being a chair of a committee or a chair of a section has a lot of different roles to it, and the section chairs have varied over the years. Some have been very charismatic, some have had some strong issues that they've advocated, and some have had some strong management skills. We've had a whole range of things. And I would say that my strength is probably organization and management. And again, it was in part in self-defense that I had a project, but I wanted other people to get involved and to participate in it. And then we could all share in the success or failure of it. And so I think that's the secret. It's organizational kind of management thing, and it's not difficult. It's not difficult.
Well, you're certainly very good at that. I can attest to that.
Well, thank you.
So, how has the section changed over the years?
Well, I do think it has changed. I have always been a very strong supporter of the section because I just think it's so productive and it's open. It doesn't rely on corporate sponsorships. The old saying, you have to earn it. You earn it is basically what this section has done. Yeah. But I do think it has changed. I think, in some ways, subtle ways, in other ways, more global ways. I think one of the changes has been all the technology. It has responded and used the technology. I remember when I was chair, we were just starting to distribute things by email. We were just starting to have a few email discussions. I would send out in a very rough way something every month. Now, if you look at the section, they have a very good website. They have much more on it. Their monthly announcements are much better, much clearer. And they've done teleseminars, this type of thing, on a regular basis, which is wonderful for the membership. Most of them are free, So it's just a great service to the antitrust community. But I do think the fact that they've been able to keep up with the technology is reflective of this group of people who really care about being up to date, being efficient, offering the best services that they can to their members. So that's clearly one thing. The other thing that I've seen change is the growth of the international aspect. Okay, when I was chair, we did invite some of the government officials from foreign countries to come, and some did come. And we had a few come to our spring meeting that were, that would come to the meetings, but they weren't really members of the section. And now, of course, the non-U.S. participation is significant. There are many leaders that are coming and are interested in coming. We have a full international track. And when that volcanic cloud settled and we couldn't get all of our EU and speakers here, it was a big deal to the section. So I think that has been a huge change and a very welcome change. And so I think both of these things are very, very positive, that the section has kept up with the technology, but they've also expanded in terms of the global aspect of the practice to invite other people into what is a very good section.
That's great. Well, I'd like to go quickly through a few more questions.
Okay.
We've talked about your contributions to the section. Mm-hmm. Are there other accomplishments that I could draw you into talking about?
Not too much, Mary. I think my accomplishments are mainly private, I would say, and I would also say that the public accomplishments are probably those that are through the section mm-hmm. that you would know about. I think that personally there have been some accomplishments. Someone once said to me, when you're working on a job, I'll say a career, you do 1/3 of things that you're very comfortable with, and you do 1/3 of things that you're reasonably comfortable with, you have some expertise in. And then you have another third that are just really beyond you. And you need to always stretch to get into that other third. And it's always been that piece of it that I've considered to be my personal accomplishments. Knowing that things that I never thought that I would be doing or never thought that I would be capable of doing, I've just said I'm going to do it if the opportunity presents itself. So, and I also feel that I've survived. I think that to survive in a very competitive world with a lot of ups and downs in terms of antitrust is in itself an accomplishment.
I would agree with that. Absolutely. How has the practice changed since you first began?
I think it's changed dramatically. And actually, as I was thinking about it, it probably has changed in the way that the section has changed. We have all that additional technology that we didn't have, which provides so much mobility that we didn't have. I remember when I first started to practice, I needed to be in my office. They needed to know where I was. And there was no voicemail, and there was no email, and that's not that way anymore. Now you can pretty much practice wherever you are, so that's changed. And then I also think that with the globalization of antitrust, it's just become more complex and more challenging, not only from a legal perspective, but just in terms of dealing with different cultures and different expectations. For me now, to deal with a U.S. client is kind of a luxury. We kind of talk the same language. But if there are clients that are in Japan or in Germany or in Australia, there are other challenges that are associated with that representation, and I think that has changed and probably changed for almost everybody in one way or another that practices antitrust.
Right. Mm-hmm. Just quickly, we're almost out of time. On healthcare and international, any quick words of wisdom?
Well, probably not. Healthcare, I guess I will see what happens with the reform and hope that it's become more competitive. I've seen a lot of changes in healthcare. Consolidation has been one main factor. The need for greater efficiency has become another. And of course, those are consistent with antitrust analysis. On the international, I'm a big supporter of any kind of convergence, procedural, substantive convergence, whatever we can do. I know we have a long, long way to go. If we started in 2001 talking about procedural convergence on merger control, we've made some progress, but not enough. Yeah. And for companies that do business in many jurisdictions, this is a big challenge, and in some cases a big problem. And so anything that can be done to move toward that, I guess I would be in support of.
Mm-hmm. Well, would you encourage young lawyers to go into antitrust today?
I would.
And why?
I would.
Why?
I would. Well, I've enjoyed it so much that I would encourage young lawyers to go into antitrust. I guess I would say that it's important for young lawyers to find an area that they have some passion about, and if that's antitrust, then that's good. I would probably also encourage them to be flexible and open to new challenges and new opportunities, and to kind of jump that extra mile into whatever they need to do to continue to be challenged and to continue to look at it as a lifetime profession or career.
Well, you've set a great example for them, and I think that's great advice for us to end on. Thank you so much, Roxane.
Well, thank you, Mary. Thank you very much.